Hi, everybody, and welcome to FH&P Lawyers Law Talk, where we talk about different legal issues every couple of weeks. And today we've got a great topic. It's the brand new decision from the Supreme Court of Canada, which recognized a new tort called intimate partner violence. And we've got our associate David Horvath here to talk about it. You've read this case, I guess.
I have read 255 pages of it, yes.
It is a big deal. And so for our listeners, you probably heard about it. You've heard it probably discussed on the radio. It's been on all over the news and all over the websites. This has been considered a landmark decision. What's it about?
It's about a married couple. They had a 16-year relationship. There was various levels of abuse in that relationship. The husband engaged in what the court called coercive behavior. This included things like sexual abuse, financial abuse, psychological abuse, verbal abuse. So very serious things. And 11 days of trial later, the lower court decided that these things constituted a tort. And as you and I know, a tort is a cause of action. It is a way you sue someone. It's a basis for which you sue someone at law. It's the same thing as negligence. So the lower court said, there is this tort. The Court of Appeals said, no, there isn't. And then it went all the way up to the Supreme Court of Canada. And the Supreme Court of Canada, with a decision of 5 of 8 of the justices, said, yes, there should be this tort of intimate partner violence. And here's the test. And off you go, and we will see many, many decisions in the future in this area.
Yeah, so for our listeners, a tort is a civil wrong. It's a cause of action. And so you can't just say, oh, I'm so mad at this person, I'm going to take them to court. You have to fit it into a cause of action. It has to, fit into a certain set of facts. And this is a whole new cause of action. And there's some concerns. And I'm going to be talking to you about some of that later, about a whole new cause of action. So this is kind of like assault is a cause of action. And negligence is a cause of action. It's a whole new cause of action called intimate partner violence. Okay, so now recognize anybody, I guess, now can bring this cause of action up and sue as long as they fit within the facts. So what is the legal test for what the tort of intimate partner violence is?
Well, the court distilled it to 3 steps. First, the abusive conduct arose in an intimate partnership or its aftermath, which is interesting. It had to be intentional, so the conduct had to be intentional.
It does not have to be intentional, personally.
Not necessarily. The court's test specifically said, and I wrote it down, it's that the defendant intentionally engaged in that conduct.
Right. Okay.
So it's not that they went about and said, I'm going to coerce this person into a relationship.
Right.
But that's different from what the court said. And I think that's what you're engaging with, is the conduct itself indicates that there's some sort of intention. So an example would be financial abuse. So one person holds the finances throughout the relationship and gives the person a certain stipend, and they use that as a measure of control. It might not be intentional by saying, I'm going to control my spouse to do X, but they do that conduct, and from the act of doing that and proving that in a court of law, the court says, okay, I can infer that intention that you did do that intentionally, because what other thing could you have meant to do, right? So that's why the second stage of that test is that the defendant intentionally engaged in that conduct.
Okay. And so what is intimate partner violence? What does that even mean?
The court says, it is best understood as coercive controlling conduct that undermines the autonomy in insidious ways. So things like sexual assault, financial manipulation, financial control, psychological manipulation. The court did say something interesting what it is not. So it is not a dysfunctional relationship. It is not a bad marriage per se. It is something more. It is something where the person, the victim, the spouse alleging the tort is no longer able to be themselves. They're not in control of themselves. The other party is. That's why there's this coercive element to intimate partner violence. And the court interestingly said this, and I'll quote it. The intimate partner is not simply seeking compensation for the physical, psychological bruises that are recognized by existing torts. In effect, they are alleging, quote, I am not just a bruised spouse. I am an unfree spouse. And that's what the court means by control. So they're not free to do whatever they like, whether it's finances, whether it's going out with their friends. A particular aspect of intimate partner violence is this level of isolation. So we see that in things like elder abuse, for instance. So similar kind of conduct, but again, it's a significant sort of conduct that is not just an unhappy marriage. And that's a specific thing the court engages with throughout the decision.
Okay, I've got some questions, but I'll leave them for now. Now, what sort of damages is a person to get? I think in this case, the plaintiff was awarded $150,000, and that's non-pecuniary damages, I guess?
It's non-pecuniary damages, so what people would know as pain and suffering. Mm-hmm. That's also aggravated damages. That's also punitive. So,
did she get all three in this case?
So at the trial level, she did. So at the trial level, she got $150,000 for general damages, aggravated damages, and punitive damage each. So $150,000. But the Court of Appeal reversed that and got rid of punitive damages. So what she was left with was general damages for $50,000 and another $50,000 for aggravated damages. And the parties before the Supreme Court of Canada agreed that was enough. They're not going to challenge the damages award. So when the Supreme Court of Canada got a hold of the case, they weren't engaging with, well, should this be more or less?
Or the categories are proper because, it seems like a tort like this, you'd almost always get aggravated damages, wouldn't you?
Oh, yeah.
It's like assault, a civil assault or something. You get a certain amount for pain and suffering, a certain amount for the aggravated nature of the tort itself.
Exactly, but the court was interestingly very specific about this. The fact that it's an intimate partner violence or this conduct is this coercive conduct, that's not an aggravating factor here. That's part of the tort itself. So it's interesting that the court never ruled on the damages aspect of it, whether or not this rises to that level, because that was not before them. It'll be interesting to see how other courts, once this rolls out and people are suing people over this and we get trial decisions, how the court actually engages with that. I agree with you. It's going to include general damages, probably punitive damage, and aggravated damages. But the court was very clear in this decision that the breadth or the nature of the damages is going to be tied to the nature of the conduct. So the more egregious the conduct, the higher damages. The less egregious, lower the damages. So this case is not really a case law for the amount of money people will get necessarily. That will be done by future cases as they go through the courts in the years to come.
How long were they together for? Was it 11 years?
16 years.
16 years.
And
so
they had children.
16 years of coercive control,
Yep.
$150,000 in this case, which
this case.
might be different in the next case, but kind of gives our readers or our viewers some context, I guess. So, okay, and I see in your notes here you've got, you can't claim all kinds of damages. What does that mean?
It's not like personal injury necessarily. So this sort of tort is interesting because it comes out of the family law context. So you and I know family law claims are a bit different than a car accident or a general assault by someone in the public. In a family law case, you're going to have spousal support issues, property division issues, etc. And you can, in that family law dispute, also sue for torts, like prior to this, assault and battery and intentional infliction of emotional distress, and now the tort of intimate partner violence.
And just for some foreshadowing, I'm going to be asking you about why we needed this one, but anyway, go ahead.
I mean, the Supreme Court of Canada says we need it so that,
Okay.
The issue with damages is that how do you compensate a person in that context? So like you said, you can sue outside of that context, so you can file a notice of civil claim and not be a part of the family claim. But it's better if you do. So let's say if the the victim or the person who's suing, they weren't able to work for that 16, 20 years. Are they entitled to damages related to their inability to work or the impact on their employment in the future?
Well, it makes sense. If part of the coercion was keeping a person from getting a job, wouldn't they be able to?
They would, and I would argue that they would. The decision doesn't indicate that, but it leaves that open and silent. But my point is that in a family law case, you're also suing for spousal support. So how does that spousal support, that award you get based on the Family Law Act, the Divorce Act,
kind of overlaps it, and you'd be worried about double recovery.
Right, exactly. So you might have, let's say it's $200,000 the spouse receives for the tort of intimate partner violence, but then they also get spousal damages. So the Supreme Court of Canada says, okay, we leave that issue up to the trial judge. So when people go into court in the future, they're going to claim all of these things, right? And they're going to get spousal support. But how does that impact that $200,000 that they may get for this tort? And it's likely going to reduce the amount to a certain extent. But it's always a good idea to do it at the same time because you're also dealing with property, right? And you and I know if you're suing someone for, let's say, negligence of any kind, recovery is difficult.
Okay.
Right.
I've been.
Okay.
I want to ask some questions.
Okay.
Here. I guess, one of the things that to our viewers, what sometimes lawyers worry that decisions are going to open the floodgates of litigation, is what we say. Isn't this going to be weaponized? I mean, it's hard enough to get divorced right now. Isn't this going to be something that an aggressive family lawyer is going to include in every pleading? Isn't this going to create a whole bunch more litigation? Is it going to be weaponized?
Those are two questions.
Okay.
So, weaponized, certainly. Family law disputes are notoriously difficult. They're emotionally driven. So yes, and we're trained as lawyers to include every claim in an action. So whatever we can throw into a notice of family claim, we will do that if the facts are there. So yes, it will be used. It will be weaponized in the sense that it will be thrown into a claim. But is that going to open up the floodgates? Potentially.
But wouldn't it? Because when you think about the nature of the action, in this case, they're together for 16 years. So as part of that, they have to show coercive control for the whole time. Whereas instead of arguing, well, I want some spousal support and you make this much and I make this much. And, right. It seems to me it's going to add a lot of argument and time into a family law case.
I disagree with you.
Okay, I want to hear it.
In a family law case where those facts exist that establish this coercive conduct, this intimate partner violence, it's there. Intimate partner violence before the tort has been a thing. It's been recognized by the government. It's been recognized by family law lawyers for quite some time. It's always there. Mm-hmm. Now the issue is, can we do something about it? Before, what we could do about it was plead other torts. And
that's my next question is, we've got all these other torts already. If it's an abusive relationship, a physically abusive relationship, there is the tort of assault. There's, you can sue for psychological damages. I'm questioning whether we need this.
Well, so again, two questions. So the first is the floodgate issue. So I'm going to say no to that because there's already going to be those facts there. And people are going to sue on the basis of those facts. Even before this tort, there were all of these other torts that you're talking about. And that's exactly what the Supreme Court struggled with. And the dissenting justices, so 3 justices dissented, said exactly what you're saying. Well, we have these other torts. Isn't that enough? And 5 of the 8 Supreme Court justices said, no. There's a gap. There's a gap between assault. There's a gap between intentional infliction of emotional distress. So there is this overarching conduct. So when you sue for something like assault and battery, you're looking at one conduct. You're looking at someone assaulted someone on a specific day, specific time. Same thing with intentional infliction of emotional distress. What is the conduct that we're alleging? The conduct here is different. That's what's special about this tort, is that the conduct is this range of behaviors. It's not just necessarily one act. It's many acts done over a specific period of time, which we recognize as a society that is abuse. We know that it's a wrong, but what this tort does is looks at that gap between those other two torts, which were mentioned throughout this decision, and says, well, that's a wrong we haven't been able to address. And the court looks at it and says, judges haven't had the tools. And now we're going to give the judge the tools to address this issue. And whether that leads to a bit more litigation or not, the benefit of that is that people actually get to address these issues before the court and get their day in court and say, that was wrong, that thing that you did to me, whether it was financial abuse, psychological manipulation, whatever that conduct was over 20 years, 5 years, 10 years, that gets addressed and they get some form of compensation, whether it gets combined into the family law claim to a certain extent, or whether they walk away with $100,000. And that's what the court was trying to engage with.
Yeah, and well said. And I know that this case has been celebrated as a case that is improving victims' rights. It's there to address a gap, I guess, that's perceived to be there. And I guess that, you've got the victims' rights on the other side, and you've got, the weaponization, which I worry about on the other side. But I guess we'll see where it shakes out.
It's a valid, I think, concern. And I think the court was alive to that. And we can see that in the dissenting opinions. But interestingly enough, what the court also left open, looking at the decision, is this tort changing in the future. So right now we have this tort of intimate partner violence. That's what we have right now as we're sitting here. But the court specifically said at a paragraph, it said that this doesn't bar or this doesn't stop the court coming back and ruling that there are other torts similar to this with different family members. It's a parent, a child, another family member. Because again, we're dealing with that that wrong conduct of that coercive behavior, that control, which I also practice estate litigation, and that in the form of elder abuse is very difficult to engage with. But it's the same conduct. It's isolation. It's that manipulation, that psychological manipulation, and that wrong. It hasn't been addressed in the same way as now the tort of intimate partner violence has. So the court left that open, left the door open at least a bit for future cases to look at that.
Because this case doesn't deal with those issues. And that's one of the critiques, I think, was that it was maybe too narrow as intimate partner violence. But
I agree with that.
But leaving the door open, you say, we'll see what comes down the pipe.
Exactly. But to be fair to justices, you can't deal with that in this case. You have a family law case, you have a 16-year relationship, you have the conduct that the court ruled was the conduct that the husband engaged in, and you have to rule on the basis of that.
Okay. Do you want to say anything else?
Other than if you have questions about the tort of intimate partner violence, give us a call, and we'll explore your options.
Great. Very interesting topic. I guess stay tuned. It's just been established as a tort, so there's going to be a lot of lawsuits down the road to, I guess, flesh it out. And how I just worry if we're going to be going through 16 years of text messages to establish this control component. But there it is. It's the law.
Family cases were already doing that.
Yeah.
So what's a little more at that point to get some justice for people?
All right. Until next time, this is FH&P Lawyers Law Talk.